All right, we are here for rulings on the motions that have been filed by the defense. This cause has come before the court on defendants' motion to disqualify the 4th Judicial Circuit of the State Attorney's Office. Additionally, the adopted motions and her own motions, that is Ms. Gardner's motions, to adopt and supplement the arguments filed by Mr. Fernandez. And this court has conducted hearings on these matters, and I am now ready to rule. First, let me say that the weight of this decision is not lost on me, for either side. And for the defense, this court recognizes that attorney-client privilege is one of the oldest and most sacred privileges. And in my order, I have quoted the 4th District, where they said, "It is therefore not only an interest long recognized by society, also one that traditionally is deemed worthy of maximum legal protection." And so that weight is not lost on me. And equally as important is the prosecutor's role in a criminal prosecution, that prosecutors are held to the role and responsibility that goes beyond that of other attorneys. The allegations that have arisen from the motions filed by the defense are serious, and the remedy that is sought is extraordinary. This court has the authority to disqualify the entire 4th Judicial Circuit State Attorney's Office. It is a drastic measure, and the courts, higher courts than me, have cautioned courts not to use unless it is absolutely necessary. This court has gone through the analysis of both actual prejudice and substantial misconduct. I have poured over the facts that have been offered both through exhibit, evidence, and testimony. Based upon that very thorough review, the court finds that disqualifying the 4th Judicial Circuit is denied. While I will say Mr. Fernandez stands uniquely and factually different than Ms. Gardner's allegations and what was substantiated by the evidence, the two documents, that is the timeline and the text messages, the court, through its in-camera review of the timeline, does find, that is an attorney-client privilege document. There is no evidence that the state of Florida has opened it or intends to use it. Therefore, actual prejudice could not be substantiated by the evidence. The text messages do not bear the same hallmarks of the timeline, and the court finds that the text messages are not attorney-client privilege. So then I turn to the substantial misconduct. The taint procedure that was agreed to by the state and the defense brought it to the court's attention through a motion, pre-trial and pre-arrest, pre-indictment, warning the state of the type of evidence that you were about to embark on. It was an agreement that was made to a higher standard that's even required by law, a quote-unquote content blind review. That is not needed. The state could have employed the procedure suggested by the defense. It chose not to. That set the state on a series of actions and poor judgment decisions to engage with officers that were either tasked to taint review or officers that were viewing untainted materials. The state's actions left itself open to a high probability that attorney-client privilege information would be exposed both to law enforcement and to the state without proper review. The court finds that the conduct of the state is not necessarily misconduct for a few reasons that I've outlined extensively in my order. It was poor judgment. It was a hyper-technical approach to the agreement that you assured both the court ruling on the privilege issues, pre-arrest, pre-indictment, and the defense. It only ended up in a footnote because the state assured Judge Carbula at the time and the defense that it would work with the defense. It did not. So, law enforcement naively, and maybe the state naively, thought that just by avoiding email folders that it would not review attorney-client privileged information. We know that not to be true because Gardner's, the one instance was Ms. Gardner's text message. It wasn't in an email folder. We know that through the timeline. It wasn't in an email folder. So that hyper-technical view and approach to the agreement brought us here today. The court finds that that is not substantial misconduct because the state, especially in Ms. Gardner's case, when alerted, acted appropriately, disabled, shut down, restricted access to a platform, informed defense attorneys. When the timeline and the text messages came up, Ms. Dippler took herself on a course of poor judgment decisions to engage. But the timeline was not reviewed, and there's no evidence of it. So, therefore, the state, has not acted in such a way that warrants disqualification. And as I write in the order, I'm very solid that while it did not rise to the level of disqualification, it does warrant an alternative. Ms. Gardner argues that the alternative should be dismissal. This court finds that to be inappropriate. Ms. Gardner's prejudice pales in comparison to what the state did in Mr. Fernandez's case. When Ms. Gardner's attorney-client privilege information was inadvertently reviewed by the law enforcement officer, the state acted appropriately and stopped the review, sent it to the taint agent, and then nothing more was done. Mr. Fernandez, the state engaged, made a judgment call, then got the item sent. So dismissal, because a text message is not attorney-client privilege, and that is what is admittedly been reviewed by the state of Florida, does not warrant the alternative of dismissal of the indictment. So to the extent that that is requested, that is denied. The court's left with another option, and I draw my authority from the rules 3.220, and also this court's being brought this information in a way in which that this court cannot ignore. The state stands here without any credible argument that you abided by the agreement. The state stands before the court in possession of a text message that it otherwise would not have gotten because it agreed pre-trial, pre-indictment that it would do a quote-unquote content blind taint review, even though that's not required by law. The timeline goes without saying should be suppressed, and it will. The text messages because of the substantial violation of a discovery agreement, this court will suppress that as well. So you will not be able to use against Mr. Fernandez a document that you got in violation of the agreement that you entered into with the defendants. Ms. Gardner is also entitled to, and also Mr. Fernandez is entitled to, an alternative to disqualification. This court, in examining the facts, finds as though it is necessary to conduct a thorough case management discovery hearing with both sides. I'm left with the fact that I don't know where you all are at with discovery, but I do know that what was happening before these issues were brought to the court is not acceptable. Okay, so the court will be involved, can be involved in appointing, as requested or suggested by the defense, a actual taint team that consists of more than one person if needed, but I will gauge that when I figure out where you all are at with discovery. I don't know if Next Point is still shut down. I don't know if y'all have even gone through the evidence, but what I do know is that I'm going to order until that case management hearing is set and also completed, and there's a court order about the discovery process. There will be no review of Next Point and what the originals were put up and all of those things until I have a good idea that there will be no more errors in exposing attorney-client privilege information. Here are the copies of the court's order. There's one copy for an original, and you can give the rest to the parties. When would you all like to have that case management hearing?
I'll defer to defense about when they want to do it. I assume that we're still talking about the 15th for Ms. Gardner's case, Wednesday?
Yes.
You can come back to the 24th if the court has, if the court's holding any case management on that day. It's a Friday.
1 o'clock?
Yes, ma'am.
Yes, Your Honor.
All right, I'll hold it concurrently on Mr. Fernandez Saldana. Case will come back before the court on May 24th, 1 p.m. Case management hearing. Ms. Gardner, the case will be back before the court on May 15th, 1 p.m. Hearing on motion. With a secondary date, May 24th, 1 p.m. Case management. Thank you all.
Thank you, Your Honor. Have a good day.